Hi, so today my presentation will be on native title and the burden of proof that falls to Indigenous people in Australia when submitting a claim. After years of genocide, assimilation, stolen generations, dispossession, and various other human rights violations, Indigenous people in Australia are still asked to prove that they still have a strong connection to the land that was taken from them. So when the Crown should be offering a treaty and healing as outlined in the Uluru Statement in 2017, instead they offer native title, which places the burden of proof on the rightful and traditional owners of the land, with no actual guarantees of legal acknowledgement. The fact that Aboriginal and Torres Strait Islanders in Australia are seeking a formal process for treaty making to ensure their right to self-determination is not actually in itself a surprise. Countries like Canada and New Zealand both have treaties in place with their First Nations people, and these have been incredibly important steps towards reconciliation in these countries, according to both Shaw and UNCTAD. Now, what is special about Australia is the government's continued refusal to create a treaty with Australia's First Nations people. It's no secret that in 1788 sovereignty was never ceded, and it's certainly not to be shown it can certainly not be shown that it's been extinguished completely across Australia, because otherwise Mabo versus Queensland would not have had an outcome that was in favour of Mabo. So what is native title? Well, I've included a direct quote from the Department of Premier and Cabinet in WA about this, and they say that Australian law recognises that a native title exists where Aboriginal people have maintained a traditional connection to their land and waters substantially and uninterrupted since sovereignty. So a native title determination is a decision by the Federal Court or the High Court of Australia, or a recognised body, that native title either does or does not exist in relation to that particular area of land or water. It can, however, be extinguished when there is an existing freehold or a lease on that same land, which is quite often the case with Crown land. Now, there are a few aspects of native title that support economic stability within Indigenous communities, and these do need to be built on. Dodson believes that there is an increasing number of Indigenous groups negotiating resource development agreements, securing native title and land rights determinations, and establishing enterprises. So I don't mean to say that it's all hopeless. These are positive steps towards not just economic stability, but also cultural stability for these people. However, the process needs to be improved and less burden needs to be placed on Indigenous people to prove their unbroken connection to land, because in more cases than not, it doesn't actually work as it has, or as Dodson says it does. The process itself of completing native title determination can take upwards of 20 or 30 years, and then after that there's also the appeals process, which, if commenced, can actually mean beginning all over again. There's also the major disadvantage in that time frame, in the sense that elders can pass on in that time and valuable knowledge can be lost as a result, which can in turn have a detrimental effect on the claim. If you're looking at the time frame itself, even that is in violation of the government's 10 points, where they specified that you required a reasonable amount of time to assess a claim like this. I don't know anyone that thinks 20 or 30 years is reasonable. The Native Title Report as well, from as early as 2005, admits that there's also many features of native title that hinder economic development for Indigenous people too. So more often than not, the economic value of the land itself is weighed against its cultural and spiritual value to Indigenous people, and as a result there are concerns that the government's interests are actually more heavily in favour of selling the very same land that Indigenous investors, non-Indigenous investors, and the resources industry, rather than encouraging Indigenous economic and cultural stability. A good example of this would be the case of the Rabibi community versus the state of Western Australia, which I found in ACTA's reading and also again in a native title report. Now, where the claim for determination was approved, in this case, the only rights that were given to the Rabibi community as a result were for the occupation, use, possession, and enjoyment as against the whole world of the claim area, specifically for ceremonial purposes. So as a result, their rights were officially exclusive in this area for those purposes, and yet the rights associated with native title did not include any utilities such as minerals, petroleum, or gas, which were, and I quote from ACTA, absolutely owned by the Crown. Now, here you have resources and mining companies who have vested interest in the land for their own economic reasons, and the Commonwealth government, does not even have a strong track record of standing up to these groups, as mentioned by Carol and Gloria in our lecture. Megan Davis and Fredericks have both also said many times that self-determination and the right to self-governance is a central factor to healing the wrongs of the past. However, the government's continued hesitation to acknowledge the land rights and the native title of Indigenous people, and the government's unwillingness to actively participate in native title with a spirit of goodwill, such as not appealing every decision ever made, tends to impede this dramatically. Now, native title claimants are required to show that they possess communal, group, or individual rights and interests in relation to land or waters, and this has to be shown through traditional laws still being acknowledged and customs being observed by them under, again, this information can be found on the government website. They also need to show that those laws and customs are evidence of their connection with the land or waters being claimed. In addition to that, the native title rights and interests must be able to recognize or be recognized by common law, whether or not this is the case. It is itself a question of law too, so there's no guarantee of that. Now, the 10 points that were introduced by the Howard government were as follows. Firstly, native title tribunal holds absolute authority over all claims for native title. Nobody else can touch it. So state governments aren't yet empowered to extinguish native title over Crown lands for matters of national interest. Thirdly, lands providing public amenities are exempt from native title claims. Fourth is that mining and pastoral leases are allowed to coexist with native title. The Native Title Tribunal can create access to traditional lands rather than actually granting a full native title as well. A registration test is imposed on all claimants. The right to claim native title in or around urban areas is removed. The government is permitted to manage land, water, and air issues on any site, which is exactly what happened with the Rabibi trial. Also, very strict time limits will be placed on all claims. Now, I don't know about you, but 20 to 30 years does not really seem like a very strict time limit. Indigenous land use agreements will be created to promote coexistence. So those were all interested. They were all introduced in 1998 as amendments to the Native Title Act in Australia, and are obviously placing the burden again on those who are trying to make the claim as opposed to on the government. So it's not really very helpful. Now, when native title is proven to be extinguished, so when there's been a discontinuation of customs and laws or tradition or any of the following, in theory, Aboriginal people are then supposed to actually be compensated. However, for this to be done, they must also be able to prove that native title was in existence beforehand. So it's kind of a catch-22 as far as that goes. Now, the Uluru Statement from the Heart I thought was worth mentioning because the government continues to refuse to create a treaty with Australia's First Nations people. Appleby and McKinnon said that it's especially odd that the Turnbull government went to the effort of appointing the Indigenous Steering Committee of Referendum Council back in 2015 in the hopes that, using the government's words, that they could advise on the next steps towards a successful recognition of Aboriginal and Torres Strait Islander people in the Constitution. However, they chose not to listen when the statement was made. So the recommendation made was called the Uluru Statement from the Heart, and this effectively called for collaboration and a treaty with Australia's First Nation people. In this statement, the structural nature of the issues that are faced today was made quite clear, and the following reforms were asked for. So firstly, they asked that the establishment of a First Nations voice in the Constitution be made. That's to help repair structural nature of the problems faced by First Nation people, such as incarceration of their children and removal of their children. The second was that they wanted a MacArthur Commission to supervise the process of agreement making between Australian government and First Nations people. It's basically a commission to resolve conflict or to help smooth things over after conflict, I suppose. Lastly, but no less important, was truth-telling about history as a nation. This one I found really important because you find that education generally has a lot to do with what we know about our country. If we're not telling the truth to our children, then they're going to grow up and they're going to continue the same cycle of abuse that's been happening today. Unfortunately, the government saw fit not to follow through on these recommendations as yet. They basically walked out, and so it is today. The process of native title is still one of the only avenues open or available for Australian Indigenous people to gain formal acknowledgement of their sovereignty and connection with country. The burden of proof is ridiculously skewed to make it virtually impossible for determinations to be made in favour of Indigenous communities, and when they are in favour, they're often overturned on appeal, much like the claim for the Noongar people for the Perth metropolitan area. So, following through on the Uluru Statement's recommendations, while it may not make native title claims any easier or prevent the government from appealing them, it would ensure the voice of Australia's First People is heard and that they have the right to self-determination and autonomy, the ability to self-govern, which has been denied up till now, and it's something that Shireen argues for, as did Megan Davis. They believe that to move forward together requires that the government truly listen to the recommendations that are made and actually build upon them in consultation with Indigenous communities, so that way decisions about their future include them and aren't just from the government's perspective. Okay, so these are the references that I used. I hope you enjoyed the presentation and have a good day.